Good morning. The October 18, 2023 meeting of the Board of Estimates is now called to order. As the board continues to meet in this hybrid function, we ask all folks who are joining us today in the room to ensure that your phones and electronic devices are turned off or at a minimum silence to ensure not to disrupt today's proceedings. For those of you who are joining us online, if you will participate in today's discussion, the chair, the board will call your name. At that time, you'll be unmuted. Please state your name, the organization you are calling from, and then begin to proceed with your testimony. At this time, I'll ask our clerk for corrections, additions, and noted abstentions to today's agenda. Madam Clerk?
Yes, good morning. Good morning, everyone. This morning, I just have the following announcements to make. In the absence of the Honorable Mayor Brandon Scott, City Administrator Faith Leach will sit and vote on his behalf. I have the following corrections and walk-ons to note. First correction, SB 23-13515, Department of Human Resources Personnel Employment Contract for Jason Mitchell. On October the 4th, 2023, the board approved an employment agreement for Jason Mitchell for the period September 20th, 2023 through September the 19th, 2024. Please strike the start and end date and insert September the 20th, 2023 and terminate 6 months thereafter. Second correction, SB 23-12078, Department of Public Works, Sanitary Contract 966, Cleaning and Inspection of Sanitary Sewer at various locations in Baltimore City Zone A. Change order number 4. In the action requested, please strike 9/4/2024 and insert 5/4/2025. In the background explanation, please strike 9/4/2024 and insert 5/4/2025. We have 2 walk-on items this morning. First walk-on, 13863, Department of Planning Grant Agreement with the Maryland State Arts Council, Cab Calloway Legends Park at 2216 Druid Hill Avenue. And I'm just going to read it. This is from the Department of Planning. The board is requested to approve an agreement between the Police Department and the Department of Planning and the Maryland State City Council for $10,000 to create a plan for art and artistic signage with the residents of Druid Heights for the area in and around Cab Calloway Legends Park at 2216 Druid Hill. The amount of money is $10,000. And this item, Mr. President, will be going on the non-routine agenda. The second walk-on item is SB 23-13616, Department of Real Estate, sublease agreement between the Health Department and Monsi. This is for 2700 Rayner Avenue. And this one is for in the amount of $212,794.77. And this is a sublease agreement that is between the Health Department and Monsi. This item will also be going on the non-routine agenda. There are no protests or statements of oppositions this morning. Non-routine items will include 12731, the Comptroller's Office, Resolution Emergency Procurement. It would also include SB 23-13710, Law Department, Settlement Agreement and Release. SB 23-13785, Law Department, Resolution Emergency Procurement. We also have the 2 walk-ons, which are SB 23-13616, Department of Real Estate, the lease agreement with Monzi for 2700 Rayner Avenue. We also have the other walk-on, which is SB 2313863, Department of Planning, Maryland State Arts Council Planning Grant Agreement for an area in and around the Cab Calloway Legends Park at 2216 Druid Hill. I have the following abstentions to note. On behalf of the Honorable Mayor Brandon Scott, City Administrator Faith Leach, there are no abstentions. The Honorable President Nick Mosby, there are no abstentions. The Honorable Bill Henry will abstain on all travel requests. The Honorable Acting City Solicitor Ebony Thompson has SB 2313687, Law Department Travel, and she also has SB 2313689, Law Department Travel. The Honorable Deputy Director of Public Works, Richard Luna, there are no abstentions. And the Honorable President Nick Mosby has one no vote, which is SB 2312903, interagency agreement with MOED for ARPA funding, First Amendment. Mr. President, members of the board, those are all the corrections, walk-ons, abstentions, and non-routine items. Thank you.
Thank you so much, Madam Clerk. At this time, I'll ask for a motion to approve the opening statement today.
So moved.
Second.
It's been moved and properly seconded. All those in favor, please say aye.
Aye.
All those opposed, please say nay. The ayes have it. The opening statement has been adopted. I now would like to direct the board's attention to a memorandum from my office dated October the 16th, 2023, identifying matters to be considered as routine agenda items together with corrections, additions, abstentions, and no votes that have been noted by our amazing clerk. I will entertain a motion right now to approve all items contained in the routine agenda.
So moved.
Second.
It's been moved and probably seconded. All those in favor, please say aye.
Aye.
And all those opposed, please say nay. The ayes have it. The routine agenda item has now been adopted. We're going to call two items back to back, so we're going to go a little bit out of order as it relates to the numbering. There's two different items pertaining to emergency procurement and rules and procedures. One has been presented to the board by the comptroller, and a second one has been presented to the board by the administration. So we're going to call them in the order in which they have been presented. The comptroller brought this to the board several weeks ago, and the administration has one that is a similar but has some slight differences. So we're going to call them back to back. So the first item on non-routine agenda can be found on pages 6 and 7, SB 2312731, Comptroller's Office. This request is to note the resolution of emergency procurement application and reporting process. On behalf of the Comptroller's Office, we have
Good morning. I'm sorry, I'm too short for this. Good morning. On behalf of the Comptroller's Office, I'm Casey Kelleher, the Director of Communications and Policy. I'm here again to present the emergency resolution, the emergency procurement resolution that we've discussed at many meetings now, regarding how the board should be notified regarding emergency procurement. The Comptroller's Office drafted this resolution with the intention of the most public scrutiny that we can muster. So the process that we've described in our resolution would mandate that all agencies submit their applications for emergency procurements to the Director of Finance through BOE Submit, their standard portal for submitting to the board. That then would notify the Director of Finance, the Council President, the Comptroller, as well as any individuals designated to receive notice that an application has been submitted. From there, it would go through the Mayor's Office of Small and Minority Business Advocacy and Development, and also allow the opportunity for the Director of Finance to comment, to approve, to ask for changes, or to reject the application for emergency spending. If this was approved, then it would just go to the board next automatically from BOE Submit, just for the board to note it. And then after that, the agency, as soon as they get approval from the Director of Finance, it would allow them to proceed with obtaining the supplies, materials, equipment, what have you, that they are requesting. So this is a really two-step process, is that it would allow for the application to go to the director, just as the charter imagined, but it would let the comptroller and the council president know at the time of the application what is happening. And this would also just allow agencies to only have to do one process to notify the board that they would submit their application, and once approved, they could just get what they needed. They don't need to come back to the board 45 days later or however long later to tell the board again, just one process of noting it. So with that, I can take any questions, or I'll let the next person go.
Thank you so much. At this time, are there any questions or concerns from members of the board?
Yes, thank you.
Madam CAO, the floor is yours.
Thank you, sir. Question on the notification piece. So you stated that there would only be one process, so the board would be notified through, I think, the BOE Submit portal. How would the public be notified?
The public would be notified once the Director of Finance has approved it. So if you hit approve, it would, much like when Audrey hits approve on BOE items right now, it would just automatically go on the next agenda.
Okay.
Yes.
So, thank you.
You're going to ask a question to yourself?
Well, I was going to finish answering.
Mr. Comptroller, the floor is yours.
Thank you, Mr. President. I was going to actually expand on the answer for the city administrator. Thinking back to one of the several previous times we've taken up this issue at a board meeting, the mayor had made the comment that notifying the council president and the comptroller at the time that the request is made, he did not feel that that was necessarily sufficient public notice. And so what I wanted to offer on behalf of the comptroller's office is, if we move forward with this resolution and the mayor does not feel that simply notifying the council president and myself is sufficient public notice, I am happy to commit to internal policies that would require the comptroller's office to, when we receive that notice, put it on our website immediately, so the public would be notified as soon as the request was made by an agency head to the Director of Finance, if that would assuage any of the concerns of the administration.
Thank you for that, Mr. Comptroller. Would they be notified at the onset of the request or at the approval?
The way that the resolution is drafted, we would be notified as part of the request. In individual conversations since the initial presentation of this resolution sometime earlier this summer, I have expressed and will continue to express a willingness to amend the resolution to have a copy of the finance director's approval be the trigger instead of the request to the finance director. I will still point out that theoretically, right now, the items that we deal with here at the Board of Estimates constitute requests by agency for the board's approval. And we don't wait until the board has approved them to tell everybody that the board has approved them. We notify the public, hopefully a week in advance, that an item is being considered or will be considered by the board at the next board meeting. However, I am open to the concept that the true gain here in terms of openness and transparency is in what emergency procurements are being approved by the Director of Finance prior to BOE notification, and that the importance of sharing openly and transparently requests from agencies that are found to not be worthy of approval are not as important. So if that would be the defining aspect in passing this resolution, I would be happy to amend it so that it notifies the council president and the comptroller upon the director of finance's approval.
Thank you, I appreciate that. At what point would we use the system of record, which we see as Workday?
You can use Workday whenever you use Workday. I mean, one of the things that I tried not to get too confused with when we were having the conversations about this resolution is that anything that needs to be, any money that needs to be spent that's going to be approved by the Board of Estimates is going to have to be entered at some point into both Workday and BOE Submit. This resolution suggests that it go through, that the notification happen by BOE Submit. I have expressed, and I will continue to express my willingness to amend the resolution if necessary to work through Workday and to have Workday be the formal instrument of having the agency request the emergency procurement from the Director of Finance and have Workday be the system which automatically notifies the Council President and the Comptroller when either when that request is made or when that request is approved. At that point, they will, the agency will still have to, or I guess technically the agency or the Finance Department will have to put that item into BOE Submit to send it to the BOE to be noted after the fact. But either way, both systems are going to end up getting used. And I don't care which one notifies the Council President or the Comptroller as long as there is an automatic process that provides that information to entities outside of that relatively small and tight administrative circle.
Thank you. Thank you. One last question. So as everyone on the board knows, and I think the general public knows as well, that oftentimes we are faced with a number in a variety of emergencies, and some of those require immediate approval by the finance director in order to move forward. A garage collapse, there could be any number of life-threatening emergencies that we are navigating. Does your resolution speak to what notification looks like in that process, where you are not able to go in and use BOE Submit?
Well, okay, actually, go ahead. Yeah, we'll take turns. You go.
The resolution doesn't speak to in cases of extreme emergency if that happens. It does speak to if it's not operational. We'd be happy to amend that in. I'm unaware if the other system does. And in reviewing, though, I would say in reviewing a lot of the emergency procurements that are sitting inside the system right now, I see a lot of things I think that waited a few days anyways for approval from the director. So we can definitely amend it in so that people use it automatically. But we just want to make sure that there is a practice that is audible and efficient for agencies to send in their applications.
Ms. Keller, for those extreme situations, would you be willing to amend maybe your resolution to state that since the data input would get in the way of ensuring that this catastrophic event, we couldn't treat it right away because it's such an extreme situation, that when the director of Finance receives it, that a call is given or an email is sent to the Council President's office and the Comptroller before it's then put into the system whenever the administration has time to. I'm just trying to figure out another pathway of notification that would be acceptable for an extreme case like the Madam CEO brought up.
We would be open to amending it in those situations, but I think that the application, as we've described in here, is, as short as an email, which would have to go Director of Finance anyways, and then eventually have to go into Workday so that they could make a PO to buy, pay a roofer to secure a roof in those situations. So we can amend it in situations of safety, but I also want to say that I think that at some point someone's going to have to write something down when you're paying out, $20,000 before we get the money out the door. So, it would work well in our system. I think in the situations too that are immediate, needs, like we need to buy $5,000 of water at Costco for something, that's why we have P cards. But that's why he's here, though.
I think that's an excellent explanation. Another question I have is, do your research, and I guess the motivation that brought you here today, were you ever able to uncover maybe situations where something happened, money went out the door, and the finance director kind of approved it after the fact?
Sorry, he was raising his hand.
So the technical answer to that question is we can't be sure. That is part of what we're trying to accomplish with this resolution, is that currently there is no requirement for anybody in the chain of command, request, and approval for an emergency procurement. There is no requirement for them to tell anyone outside that chain. So we literally have no idea at what point any agency head may have made a request orally to a director of finance, had it approved, and have the money spent and gone, and we were in theory supposed to be notified promptly, except we know based on reports we are now receiving from more than a year ago that promptly has not always been defined as anytime soon. So we literally can't know the answer to that question in full.
So based off of your research and experience, we don't know if there has been a situation like that. However, the way the current process is set up, there are some concerns that it could happen that way. Is that accurate?
I think that's accurate. I think that I would, and following the emergency procurement reports that have come to the board in the past few years, I would say the main reason for them is because the procurement process sometimes can be arduous and can be a little bit, it take a long time in situations where it's an emergency, you need to move quickly, or when you're faced with things like the supply chain issues that we have. I think a lot of these solutions have been city employees getting really creative about how to fix issues in their agency, and then going to the director of finance to be like, I have this huge issue, I need you to fix it. And the director of finance saying, we absolutely need that, and you have a solution, I will approve that. Yep. The issue, and I'm not saying that is that they are going around the reins of, I think a lot of the time I've researched that they've had a lot of issues trying to push something through, and so they have been approaching it by, we need this supply right now, and if the director of finance can bless it, then that is what works for us. But we don't have a complete picture because it's all dependent on what's coming to the board. And the last slot of emergency procurement reports we got were the first ones. We got them in July. Were the first ones we'd seen in about a year. So I can't give a good picture, and this is also anecdotal based on our discussions with agencies and helping them get things to the board.
Thank you. Madam Solicitor, did you have something to say? Or, I thought I heard something over here.
No,
I'm sorry,
Mr.
Madam,
President.
I'm Madam CAO. Did you have something to say?
Yes, I just wanted to actually respond to that. So I think From my time in this role, because I also see all of the emergency procurements and weigh in directly with the Director of Finance on what is and is not an emergency. And what we have tried to do in the requests that have come into us is to actually evaluate whether or not this will call for a disruption of city services and is actually a true emergency as defined by the mayor's office in the city. We should be reminded of the number of emergency procurements that we, of course, had to do over the past 3 years at this point because of the pandemic. Almost everything was an emergency procurement during the pandemic, just given the challenges that we faced. And so I will acknowledge that there were some challenges, especially with the pandemic and reporting back on emergency procurements, which is why I do appreciate the comptroller, your efforts in really pushing us on this issue and having us have the conversation about how we put forward a process that is fair, that is transparent, and allows for city business to get done without interruption and without delay, especially the reporting back to the public. Of course, we do have an emergency procurement resolution that our team has drafted, but I did want to push back a little on just the premise that we are approving emergencies just so that people are not going through the procurement process. That is not something that I allow, nor is it something that the finance director allows.
Mr. President.
Mr. Comptroller?
Speaking specifically to that point, and without narking out any particular agencies, I do feel obliged to say that in conversations with agencies about their emergency procurement requests, we have basically come to understand that there are two kinds of emergencies. There are emergencies of circumstance where something happens. A chunk of cement falls out of a garage floor, and something has to be done immediately to handle that. But the other kind of emergency that agencies deal with is, and again, not meaning to throw the current director of procurement under the bus, but throwing their agency under the bus. There have been multiple instances over the years in which agencies went to procurement and started what they felt was the procurement process for something with plenty of time, and procurement did not deliver the needed items quickly enough. And so the example we've been using in conversation is DPW needs chlorine for water treatment, and when they get to we've got 4 months left, they would put in a request to procurement, and that should be plenty of time to buy another shipment of chlorine. But then the week before you're completely out, you still have no chlorine yet. Now it's an emergency that we have to just go buy chlorine somewhere and get it delivered next week. And that's a legitimate emergency procurement. But here's where the notification at the point of making that request becomes important. Both procurement under the finance department and DPW report to the same entity. And in a situation where DPW has to buy chlorine the week before it needs it, if that were released publicly, it would have to be acknowledged that somebody screwed up. Either DPW screwed up by not ordering it in time, or procurement screwed up in not providing it in time. And both of those entities that screwed up report back to the same person. And as I have stressed many times before, and I will stress again now, not talking about anybody who's in current positions right now, I will say that it is a bad idea for us to continue to run tens of millions of dollars of procurement on an honor system when it would be in the best interest from a comms and PR perspective for that mayor in that situation to simply not hurry to release the report that had happened. And I understand that there have been suggestions, and will be one codified by the law department's resolution, that we simply work harder on ensuring that the report gets made to the BOE in a truly timely fashion. But our concern is that does not close the loophole that allows for the administration to simply not do it. And no one would know that it hadn't done it, because that is not open and that is not transparent. And without that, there can be no accountability.
Thank you, Mr. Comptroller.
Madam CEO.
Sorry. Thank you, Mr. Comptroller. And again, without going further into the resolution that the Law Department has drafted, I think the administration has attempted to meet the spirit of what you are attempting to do. And so I think what we will see is that there is a closure to that loophole, in that the notification is codified in the procurement resolution that we are putting forward, where the comptroller, the council president, the entire board would be notified immediately after the approval, and that the public would be notified at the next board meeting. So we did attempt to address that.
Mr. Comptroller.
I will hold my response to that last part until we're talking about specifically the future resolution, but I just want to set up now, while we're talking about our resolution, that there are two different problems here that are created by the way the charter amendment, the way the charter provision for emergency procurement is written. The two different problems are, one, it only says promptly for defining when the Board of Estimates is notified after the emergency procurement actually happens. And I appreciate the fact that both of the resolutions that have been submitted on this topic address that issue. But the first and more important problem that the emergency procurement charter provision creates is that no one knows what has been approved except the people inside a very small circle in the administration. And it is not until they choose to share that information with the rest of us in the notification to the BOE that that information actually becomes public knowledge. And unless you're also going to give somebody outside of the administration access to Workday, we can't even go in and look at what requests have been made. We have been trying since this summer to get a list of what emergency procurements have been made and approved. And in the absence of being able to get that information, we will never, ever be certain that the reports that are brought after the fact to the Board of Estimates are complete.
Madam CEO.
Yes. So thank you for that, Mr. Comptroller. I think we are absolutely open to ensuring that you have access to Workday so that you can receive the notifications and I'm trying not to get too ahead of ourselves here with the next resolution up for discussion, but you can absolutely be added to the circle, and you can absolutely receive access through Workday so that you can run reports and see the emergency procurements that have been approved.
That would be wonderful.
Thank you. I guess, Madam CEO, your dialogue and discourse today regarding this routine agenda item, is that kind of the response from the administration, or should we call up the CFO or Deputy Solicitor?
I think you good, Stephen? Yeah. Okay. We'll
you
call
want to come up?
Deputy Solicitor.
All right, all right.
Thank you, Mr. Council President, members of the...
So just for the record, Deputy Solicitor, if we could just talk specifically about the administration's concerns, support for the comptroller's resolution, and just from a housekeeping perspective, I think it's probably best for the public and for this process that then we allow the opportunity to kind of present the other resolution. That way, from a discourse, the public will understand and know the deltas between the two, and then we can figure out a way to then go and vote each one up or down. Does that make sense to you? Okay, perfect. So, Deputy Solicitor, if you could talk specific about the concerns or support of the comptroller's resolution.
Absolutely. Thank you, Mr. Council President, members of the board. I'm Stephen Salisbury, Deputy City Solicitor. I'll talk, we've talked about the comptroller's resolution. I think there's one very specific issue that, the law department had flagged from the outset about the notification requirement. It's hard to discuss that without talking about ours, but I know I'll follow your process,
Well,
which is...
You can if it kind of changes your concern. So I assume that you guys came up with a new resolution because of that concern. So
Yes.
you can kind of talk back and forth between the two.
Absolutely. I appreciate that. I mean, honestly, listening to this dialogue and this back and forth, I think we have drafted a resolution that basically addresses all the concerns that we had talked about here today. It addresses the issue that is why the comptroller, I think, and we really commend the comptroller for pushing this process from the outset, which is, something that happened in a previous Board of Estimate meeting where we have an emergency procurement that is being reported on months or even more than a year after the fact. That's what this process was meant to address. The law department's resolution accomplishes the transparency into that process by ensuring that as soon as an emergency procurement is approved by the Department of Finance, it's going to go to the next Board of Estimates, on the next Board of Estimates agenda. That means not only will the comptroller and the council president know about it, the whole world will know about it because it'll be made public. There's one very specific issue that we had flagged from the outset with the comptroller's initial resolution, which was putting notification of the board prior to the approval of an emergency procurement. And our resolution, which we feel to be inconsistent with the charter, this is something we've talked quite a bit about because the charter in our reading makes clear that in these emergency situations, a process for procurement is set forth that allows the Department of Finance, the Director of Finance, to approve procurement of supplies and materials in the case of an emergency without first going to the board. And we wanted to make sure that whatever the resolution, while important to address these long delays, and again, we think that that was critical and we wanted to do that, we think our resolution does that, it does so without while being consistent with the charter, which puts the Director of Finance's approval prior to notification of the board. So again, we can talk more about our resolution. I think in just about, it largely mirrors the comptroller's resolution. It was, I'll be honest, it was modeled off of the comptroller's resolution with that one change. And again, to the loophole that was just discussed, that has been closed because when if an emergency arises, an agency goes to the Department of Finance to get approval. Once it is approved, it will go on, the noting of that emergency procurement will go on the next Board of Estimates. So we're talking about days, not months or years, and that is public for the whole world. So we feel like that brings the transparency into this process that we all wanted to bring into the process, and but does so while being consistent with the charter.
And I guess the assumption, not the board, but I think it's specific to the council president and the comptroller being notified of a request, you're saying that's inconsistent with the charter?
Correct. We are saying that the charter clearly sets forth, and I could read from the charter provision, but that in these emergencies where the public welfare would be adversely affected by awaiting approval of the board, the Department of Finance, the finance director, has the ability to approve the procurement. And again, we're talking about, The issue that we wanted to address here is these long delays where the public is not aware of the emergency procurement until months, sometimes months or even longer after the fact. And we feel like that was addressed by ensuring that it's going to go on the next Board of Estimates agenda immediately following approval.
Understood, but I guess just quickly back to my question, where in the charter does it like disallow for the notification to go to the council president or the comptroller? From what I'm hearing in the resolution, there is no a part of the resolution that states that there would be a vote by the council president or the comptroller, or the council president or the comptroller would have the ability to deny it. So I would assume that that notification going out directly to the Department of Finance, to the finance director, he or she still has the ability to either approve or disapprove of whatever the request is. I think that is what's really consistent with the charter. But whether the notification goes to the mayor or goes to the council president or goes to the comptroller is not factored in the charter definitions.
I think we talked about this extensively when this first came up. I mean, it's not inaccurate to say that the charter does not explicitly say, you shall not first send the request to the council president and the comptroller when the application is happening. What we are doing is we read that provision to make clear that in these cases of emergency, the approval of the obtaining of supplies and materials to respond to that emergency are solely within the authority of the Director of Finance. And that's how we read that provision taken together. We think it makes sense when you read it with the other emergency procurement provisions. And again, I think that the issues that we're talking about here, the problems, the scenarios that are described are still being addressed, because whether, in the chlorine example that the comptroller mentioned, I think that you are, I don't want to speak for the comptroller, but I think that in that scenario, you aren't assuming that even if the request went to the comptroller and the council president for the additional chlorine to, avert catastrophe, that it was going to get rejected. So it's still, right, so we're still having, the approval is going to happen and the public is going to be notified, again, in this resolution, immediately, once the approval happens. So that's my point, is just, I think we are solving the issue, the problem that we set forth to address here. But again, we are maintaining consistency with the charter.
Understood. I think two things I have to say. One, again, I think under the resolution, consistent with the charter, that the CFO, the Director of Finance, has full autonomy to approve or not, any request that comes in. It's literally just a notification. I think that, from a council president's perspective, not from a comptroller or anyone else up here, but, my job of overseeing the legislative body in the city of Baltimore. And one of the major functions of our job is agency oversight. So for the instance of the chlorine, yes, it was great that we go down that process. Again, whether it's the comptroller's resolution or your resolution or kind of what we do today, the only one that kind of shows some level of inefficiencies associated with the procurement process, with maybe issues inside of agencies, is having that notification. Because we would be able to see a trend, or we would be able to see a pattern, or it would highlight some concern for the council. As we've gone down this path of having more authorization inside of this budget process, the council in 125 years for the first year had the ability not only to cut funds, but also redirect those funds. We've stood up the Finance and Performance Committee to do just that. We don't want to just turn the budget cycle in kind of going back and forth and understanding what the inefficiencies are with agencies based off of questions and concerns that we are seeing ourselves or we're getting from our constituents. But we want to turn that into a year-long process where we can actually ask agencies what's going on. So maybe from codifying it through law, or maybe from working with the administration and working with the comptrollers and other folks around city government, we can help drive more efficiencies. So I think I think what it also does, a third point, I think what it also does is, we've seen things come through this body that weren't really emergencies, or at least from my perspective. And not to say that it's overly abused, but I think that as it relates to ensuring that the things that actually go to the finance director and giving him time to have his due diligence to actually approve things that are actually emergencies, I think before folks click that button, they'll decide, is this really an emergency or not? Have I done these steps that I'm supposed to do to go in front of finance? So I guess that's where my concern is. Again, the point, I'm not understanding or seeing any area inside of what this resolution is doing that kind of goes against what the explicit language is inside of the city charter.
Yeah, so I would just say two things. One, with respect to the definition of emergency, I think this is another issue that we feel like was talked about a lot when the comptroller's resolution was brought forward. Again, the law department's resolution also attempts to shed some light on defining what an emergency is by clarifying and sort of addressing sort of how we are thinking about these two different categories that the comptroller talked about. So again, another way that we feel like our resolution has addressed the issues that we're sort of talking about today. The first point, the earlier point that you had made about oversight and transparency, again, I think in this, with the resolution that the law department is putting forward here, you would have that opportunity because immediately, once that approval is made, not 6 months or a year later, you would immediately have the ability you would immediately learn of the approval of the procurement. I would also make clear that once you know about that, once the council president and the comptroller are aware, the board has the ability to call people before the board, even before the 45 days that we talk about, making the more full report. Or if you feel like, it should, that we need 60 days and you think that you want to ask questions about that. Or if you just want to talk about or try to identify the sort of inefficiencies that you're describing, that is all possible with the law department's resolution.
Yep.
Madam CEO?
So I just want to underscore a few things, and the deputy solicitor did just mention it, but I want to make it very clear for everyone that in the resolution that is being put forward by the administration and the law department, notification does occur. Notification occurs immediately after the procurement is approved, the emergency procurement is approved. Now, the other thing that we should talk about here is the deliberative nature of these emergency procurements. We have not decided at that point, once an emergency procurement is put forward, there is a process that we go through to determine whether or not that is a true emergency that should be approved. So we talked, the comptroller spoke earlier about how, how procurements come to the board and the board votes on those procurements. By the time a procurement comes to the board or a contract comes to the board for the board to vote, the administration has already deliberated on that. Right? That is how it made the board agenda. There are a number of procurements that start that don't go all the way through the process for any number of reasons. Maybe they're not approved by the administration, or there could be any number of challenges. What the board gets are the ones that the administration is comfortable with putting forward for a vote. And so in the same vein, that is what we would be doing at this point with notifying you all of the approved emergency procurements. I myself have worked with the finance director to deny multiple emergency procurements. Not all emergencies that come to us are actually approved, right? Which is why I would call those deliberative, and what you would be notified of, or what the board would be notified of, are the ones that the administration supports, stands behind, and ones that we are approving.
Mr. Comptroller?
Actually, I have a couple things. First of all, I didn't want to appear ungrateful. I appreciate being commended. I appreciate being appreciated. I did want to also, however, be very candid that in the last almost 3 years, there have been more than one occasion when an item that had been through the deliberative process inside the administration was submitted to the BOE for approval, and with that advance notice that the council president and the comptroller received by having it submitted to the agenda, when we asked questions about that item was withdrawn. And sometimes it came back changed in a way that we, all agreed was better. Or sometimes it didn't come back. In an ideal world, that would be taken as evidence that maybe including other city officials who are not all working for the mayor into the thought and deliberation process is beneficial to public policy. I think you could say that is the point of the Board of Estimates. The council president and I are not going to determine whether something passes here by our vote, but we can share input, experience, way of looking at things that may not be something that is already available inside the administration. That is arguably our biggest purpose on this board. And so on one level, the concerns that I have raised about the emergency procurement process is it completely removes us from the procurement process under the guise of timing. And the reason I say under the guise of timing is it costs no time to notify us at the same time that the Director of Finance is being requested to approve this action. It costs no time, but it gives us the opportunity to report directly to the city administrator, to the Director of Finance, to the mayor, whoever, any concerns we might have about this before it is literally a done deal. Things may be done deals when they come here to the Board of Estimates in the sense that they're going to get approved, and the concerns we raise are the concerns that we're just going to share with the public for the public to consider in its ongoing assessment of our individual and group performance and in the public's need to hold us accountable for the decisions that we make. But it's really also an opportunity for us to provide you with help and assistance. And I got to be honest, despite the good, warm feeling from being commended and appreciated, it's a source of great frustration and confusion to me that the amount of effort you've put into resisting solving the first problem is an open rejection of the idea that maybe there is something else that could be offered by the comptroller and the council president in your decision-making process, which I gotta say, I suppose I could be accused of being arrogant in thinking that I have something to offer, but I think it's also arrogance for the administration to feel like we don't.
Yep. Thank you.
Madam CEO.
Thank you. So I just for the record, I want to state this and be very clear. And I know that you've already appreciated being appreciated, and I'm going to appreciate you yet again. Both of my colleagues, I appreciate and have appreciated in my 7 months in being in this role, the input and the feedback that I've received and the partnership that I've received from both the comptroller's office as well as the council president's office and the entire board. So I don't want you or the public to view this as us not being appreciative of the partnership, of the support, of the input. You are absolutely correct in that your input and your insight, both the comptroller and the council president, has caused us to reevaluate things. Whether it's procurements or just general policy that we are undergoing, and we have attempted to strengthen our communication so that we are making you aware of big policy decisions that are happening prior to us moving forward with those decisions. I can only speak for, what has occurred under my leadership and under my tenure. And so this in no way is an attempt to undermine that partnership and that communication that this administration values in both of your offices.
Thank you, Madam CAO. Ms. Comptroller, anything else to add?
I appreciate that. Okay.
Deputy Solicitor, anything to add?
No, I was going to say the same thing.
I appreciate that. Everyone's being appreciated. Ms. Keller, anything to add at this moment?
I appreciate the opportunity, but I will defer to the comptroller. I think we're done.
Thank you. So as we discussed, that was item SB 2312-731 on page 6 and 7 of today's agenda. We're going to pause and talk about SB 2313-785. The discussion, just for the public's knowledge, shouldn't be as long as the last discussion because we kind of debated it already. But I think it's important that we present both and then as a board move forward. So at this time, we're going to call Deputy Solicitor. Let me appropriately read it, and I'm sorry. The next item on the non-routine agenda can be found on pages 85 and 86, SB 231785, Law Department. This request is to approve and adopt a resolution for emergency procurement. At this time, on behalf of the Law Department, we have.
Thank you, Mr. Council President. Deputy Solicitor Stephen Salisbury. Mr. Council President, members of the board, as you noted, this is sort of a continuation of the same discussion, but the Law Department has put forward a proposal with the administration with a resolution to the city's emergency procurement process. We believe that this resolution will help to introduce a lot more transparency into the emergency procurement process while maintaining fidelity with the city charter. I won't go through all the details. I think we've sort of rehashed those, but I'm happy to answer any questions. And just to be clear, the Law Department would recommend approval of this resolution, SB 2313-785.
Thank you so much. Madam CAO?
So, Deputy Solicitor, do you mind walking through just the specifics, the timeline of notification, the reporting back to the public and/or the board?
Absolutely. So just to be clear, under the Law Department's resolution, when an emergency procurement is requested by an agency to the Director of Finance, it would go through the workday process. There would be a trail, a record of the request for approval. The Director of Finance would then have the opportunity to consider that, ask questions. Those questions would also go through the workday process. If the Director of Finance ultimately approved the request for an emergency procurement, that approval would immediately go on the next Board of Estimates agenda. So it would be made available, made public to not only the other board members, but to the public as a whole. Then the agencies would be requested within 45 days to bring forward a more complete report on the emergency procurement itself. And that, again, is tied back to the language in the charter requiring a prompt report to the Board of Estimates on the emergency procurement. Again, we think this is addressing these issues. We've had historical challenges around emergency procurements not being brought to the board for many months, if not longer. This would not only include immediate notification to the board to be placed on the ensuing Board of Estimates agenda, but also clarify that 45 days is what we have defined as sort of a full, thorough report to go to the board based on the emergency procurement.
God bless you.
Thank you. Mr. Comptroller?
Thank you, Mr. President. Good morning.
Good morning.
Under your resolution, the agency head would submit the emergency procurement request through Workday to the Director of Finance,
Correct.
and the Director of Finance would approve the request in Workday.
Correct.
Would Workday then automatically notify the council president and the comptroller?
I believe so. I think that, and gets a little technical, but I don't know if it would generate just a short notification to go directly to the Board of Estimates.
It can't do
go
that.
to Board of Estimates. So then I suppose it would be structured so that it would generate the notification to the comptroller and the council president, but also it would we would ensure that that was also generating a request to be noted at the next Board of Estimates, like any other matter that goes before the board.
So yes, getting into a little bit of the technical weeds here.
But yes,
Notifying the Board of Estimates is what the BOE submit system is for. So some human being would have to, after the Workday approval has been granted, would then have to go into the BOE submit system and put in an item saying this is to be noted at the next board meeting.
That is correct.
Okay.
But the automatic notification we would have so that went to the comptroller and the council president at a minimum, so that there wasn't any, so that that is an automated process.
Okay, that is actually one of the big issues we've been focusing on, is we're trying to take advantage of the fact that we now have Workday, we now have BOE Submit, we now have automatic systems, and I'll raise this issue in my next question. What is the penalty for an individual person for not following the charter?
I think you'd have to be more specific than that, but what would be I think it would sort of depend on what provision we're talking about when you say not following. Are they violating the charter? Are they inconsistent with the charter?
Like right now, the charter already says that you have to send the report to the Board of Estimates promptly, okay? But because promptly is not defined anywhere other than common sense, which doesn't necessarily have a place in a legal discussion, no one can be punished for the fact that they didn't submit a report to the board for a year and a half instead of what most people would define as promptly.
Well, I think you're talking about, does the charter create a private cause of action for violation of its terms? And I agree that's not in the charter, but I think there's any number of different legal processes. If somebody wanted to challenge some action that was taken that was inconsistent, that they believed to be inconsistent with the charter, I suppose they'd be welcome to submit a challenge to that. I think that's something that, as the law department, we're very concerned about, and we want to make sure that everything that we're doing is consistent with the charter, regardless of whether there's a private cause of action to challenge a decision that the city has taken.
And so the reason why I'm happy that we now have these automatic systems is because those theoretically take the concern about whether or not someone will do what they're supposed to do by the charter, or even by resolution of the board. If the system is programmed to automatically notify the council president and the comptroller, then it doesn't matter if some human being in an agency chooses to not submit something to BOE Submit, saying that it needs to be on So that would address our concerns. Is that clearly in your resolution that Workday would automatically notify the council president and the comptroller? And if not, could that be more explicitly written into the resolution?
I'll say, I think it's explicit. I'll read the sentence right here. It says, if the Director of Finance approves the agency's application, the approval will be placed on the next Board of Estimates agenda to be noted. It will.
That is not the same, that is not the same thing.
Yeah, if we wanted that to more explicitly say that it's going to auto-generate a notification, I don't think we'd have any objection to that, but
Madam CEO.
Thank you, Mr. Council President. So I think we are happy to work with our technical team to make sure that we can actually have the automatic notification. And if that is the case, I'm happy to make an amendment to add the automatic notification upon approval.
Okay. That was one item. The other item is, if memory serves, your resolution is prefaced at one point by the two of the most powerful words in all of lawyerdom, which are, if practicable.
yeah. So again, I think this was an issue that we were talking about with the comptroller's resolution. I think we're really more focused on there sort of the technical issues, like if Workday is down, if some of these systems are not accessible. We wanted to make sure that, that agencies didn't feel constrained to fully respond to crises if, if this technology was not available to them.
Would you be willing to, and I keep looking at you and not you, because I know you're like,
It's
yeah,
appropriate.
but you're the law department right now, even though you're here also. And the resolution is coming from the law department. So would you be willing to amend your resolution to, instead of the sweeping if practicable, simply add an additional paragraph saying, if Workday is unavailable, then the process involves sending an email to the Director of Finance, and if the Director of Finance approves it by email, copying the Council President and the Comptroller in the Director of Finance's email back giving their approval.
Wait, I'm sorry. I thought I knew where you were going with that, and then this started adding a little bit more to it that I was. Can you say that one more time? So you're saying to,
if Workday is down,
Or the system.
or if the system, well, they're hardwiring Workday into the resolution, right?
But the thing is, we're setting this up for 10 years, 15 years, 20 years.
Okay, if the system is down, if whatever financial system we're using to run everything is down, then there's a fallback of you just email the Director of Finance with your request, and when the Director emails back their approval, then the Council President and the Comptroller would get copied on that email back notifying the agency of their approval.
yeah, I think from a legal standpoint, that would not be inconsistent with
Yeah.
with the charter, but I want to.
Madam Solicitor?
Thank you. I think we need to also look at the scenario, I think, that we discussed earlier, when it may not even be practical for us to go into Workday at all. It may not be a technical thing, but it may be on the level of such an emergency where they may need to contact the Director of Finance outside of that, and then they would have to go back to do that. I think the broader point that Madam CAO is trying to bring up, while we value the input and the partnership under normal basis, this is supposed to be not a normal basis. And so the deliberation that the administration is attempting to do to decide, and that the director is attempting to decide if they want to move forward with this emergency, first determine if it is an emergency, and then if the director approves that, then at that point, it would be notified. And then, at that point, we would come.
That's what I'm asking.
Yes.
Yeah, I already gave up on being being notified at the request because you turned down so
Right.
many requests. But I'm saying that what I'm trying to get at is the if practicable means that if somebody, and from the way I have experienced life in Baltimore City, somebody could be any of a number of people. If somebody determines that it's not practicable, then everything else that we've just agreed to isn't going to technically count. And that's going to be explained, if at all, after the fact. But again, and I can't stress this enough, the danger of not taking advantage of the automatic system to do this is human beings are capable of choosing not to follow the rules, and you have a system that does not currently provide for really a large amount of accountability in that situation.
Right, I'm just saying that not practicable, it does not only include technical instances. That's all I'm saying. That I know you were suggesting language to say if it's down, but
Well,
there may be other emergencies that are outside of that I wish we would
I was going
account
to
for,
keep
which is
going.
why. Yeah.
I was going to go and then a paragraph for if you can't use the financial system and you can't send an email and you have to make a phone call, and that's how you're telling that's how you're asking for permission and getting it, is you just got to call somebody, because we know that's how it has happened in the past. We know that agencies just called the previous director of finance and just told them the problem. And the director of finance determined, yes or no, this is an emergency. What I'm looking for is, in that scenario, can we describe how the council president and the comptroller get notified after the fact? Because, as Ms. Kelleher pointed out, at some point, somebody has to write something down when we're paying other people lots of money. So at some point, we got to come back into I mean, to some extent, and maybe I've misunderstood this, I thought that Workday was now so well integrated into what we do. I'm not entirely sure how you pay a significant amount of money without going through Workday, which sort of begs the question of, if practicable being an issue, in terms of if Workday isn't working, how do we pay somebody for that, emergency service that absolutely positively has to be there overnight?
Yeah, I was just saying I want to account for other situations outside of just Workday is down or it's not up. That's all I'm saying.
Yeah,
Sorry.
and I agree. And I think that where you're driving at here about the notification, clarifying that, again, as long as our issue has always been not putting the notification prior to the approval. I think if ensuring that that's going to the comptroller and the council president after the approval in one of these other scenarios where Workday is unavailable, I don't think that would be inconsistent with the charter.
Do I hear that we kind of have an agreement, Mr. Comptroller?
Okay, then the last, but possibly most important one. So are you willing to defer your resolution and go back and rewrite these things that we've just discussed? I'll defer mine if you'll defer yours. I mean, mine's more experienced at being deferred. It's been deferred several times. It's got those deferral muscles worked, so.
I would say I don't think it's necessary, but I would defer to the board on that. I think that our resolution, as it's written, I think accomplishes that. I think it's certainly, we're open to.
I think we've just acknowledged that your resolution as written doesn't quite say explicitly some of the things that we've agreed to here in principle.
Yeah, and I think it's only fair. There's been a lot of discourse. We're hour and 15, maybe 20 minutes in. But, let me just say, from the administration, from the comptroller, everyone involved, we're not going to always agree. But I think it's this level of discourse and dialogue that's critically important for us to do the people's job. And in public, they got a chance for us to see the administration, comptroller, and all members of this board do the people's work, and not in unison always, but come to a resolution. So I just want to commend, I guess this level of discussion of showing us trying to get to a resolution for something that has been a problem that none of us up here have caused or been a part of. We're trying to fix the problem. So with that, I do think because some of the requests from the comptroller probably should be so explicit, and so there's no misunderstanding of moving forward, and so we don't have to spend another hour and 20 minutes going back and forth about this in the future, that it makes sense for us to defer for the law department to kind of work on the amending of the resolution, provided back to the comptroller, myself, and all members, and then we'll know that we'll go forward, and my assumption is the next vote will take 30 seconds. Is that fair?
It is.
All right, so with that,
I appreciate the commendment.
with that, I think we have to properly defer this. So I'm going to read both items together and just say that SB 2312731 and SB 2313785, I'll take a motion to defer these to the next BOE meeting.
So moved.
It's been moved and probably second. All those in favor, please say aye.
Aye.
All those opposed, please say nay. The ayes have it. Both items have been deferred. The next item on the non-routine agenda can be found on pages 92 and 93, SB 2313710, Law Department. This request is to approve an agreement and release due to wrongful conviction for the murder of Dwight Duckett in 1983. And on behalf of the Law Department, we have
Justin Conroy, Chief Legal Counsel for Baltimore Police Department. Morning, everybody.
good morning.
Morning.
So, as you noted, this is a case involving a murder of an individual back in 1983 by three teens. All three teens were arrested. All three teens were jailed and sentenced and spent 36 years in prison before they were released in 2019 after an investigation by the State's Attorney's Office Conviction Integrity Unit. They then subsequently filed a lawsuit against the city, the BPD, and the detectives in 2020. Now, this is a case we've been litigating aggressively for 3 years. As with all cases the law department and legal affairs faces, we know that complaints are allegations only, and they have to be examined through discovery and through rigorous litigation. This case was no different. In the last 3 years, we encountered similar flaws that the state's attorney uncovered, which is recanting witnesses, witness testimony that's been obliterated through time, detectives who obviously no longer can remember what was done 40 years ago, and three individuals who present very credibly, as they should, as three people who spent 36 years in prison. There's no getting around that fact. These are men who went to jail as teens and came out as young grandfathers in their 50s. With the Conviction Integrity Unit's overturning of the conviction and the joining of a petition for a certification of innocence, a writ of actual innocence, it's very difficult to defend this case, but defend it we did through a motion for summary judgment. A motion for summary judgment is filed when either party thinks they can win without the need for a jury. That motion has been pending before the court for a year. And it was during that time that we realized the parties had the most incentive to settle. Either side, that's my phone, it's buzzing on the table,
okay.
Sorry. I know. Either party, had that motion been granted or denied, would have seen their case weaken or strengthen. So that was the time for settlement. We've been negotiating since, I just reviewed my notes, the first mediation was in October of 2022. So this is a case that took 9 months to settle. That means those 9 months were spent with each side pushing, using a mediator, and us resolving the case for an amount that, while high, is still representing a very good settlement for the city and gives resolution to the individuals and brings the matter to a close. We, the Law Department, Legal Affairs, were not confident that our motion would be granted. Had we been confident our motion had been granted, like in other cases, we would not have really pushed settlement. But we felt our motion would probably be denied, probably, which means it would have most likely gone to a jury, and in front of a jury, for the reasons I mentioned, we didn't think our case would be strong, and that we thought this would be a much better value than a jury verdict, which has around the country exceeded $1 million to $2 million a year per incarceration. If you take the number and strip it down, you're talking about $413,000 a year per incarceration per individual. So we felt that that was a settlement that was in the best interest of the city. Happy to answer any questions.
Just for the record, what's the total settlement amount?
Total settlement amount is $48 million, and each individual plaintiff receiving $14.9 million. So that's how I get to the $413,000 per year, 36 years of incarceration per person. So 108 years of incarceration total for $48 million.
Is there additional investigation of this particular case?
This case is no longer being investigated to my knowledge because the individuals were declared innocent. So unlike cases where there's an exoneration but not a declaration of actual innocence,
Yeah.
And I think it's no secret because this case is in the media, the Adnan Syed case. Adnan Syed's conviction was overturned. There is then an open investigation to determine who committed the murder. This case is so old and is I believe it is not being investigated.
Yeah.
I can follow up with that, though.
Understood. Is there any investigation into police misconduct or prosecutorial misconduct associated with this case?
I don't believe that is being investigated. I believe that was, though, I can firmly state that was part of the reason for the conviction integrity unit's vacating of the conviction. They believe there was exculpatory evidence not disclosed and that the detectives at the time misled witnesses. Something that happens 40 years ago, again, it's very difficult with police records and with homicide records being no longer, at that point, not digitized, not maintained. It's hard to go back in time, but that was part of the release, yes.
Yeah, and I know we said individuals. Just for the record, they were juveniles at the time.
Yes, sir. They were, I believe, 16.
So maybe 15 and 16-year-olds who ultimately grew up in jail for how many years?
36 years each, sir.
36 years, and that's what we're here to talk about today, right?
Absolutely.
Are there any other questions for members of the board? Mr. Comptroller?
Thank you, Mr. President. Morning.
Morning.
I'm sorry, I missed, did you say whether the $48 million settlement includes legal or attorney's fees?
I did not say that, but it does.
It
It is
does.
a comprehensive, completely inclusive settlement.
But you wouldn't know how much the legal fees are?
3.3 million.
3.3 million.
Which, if you again factor in the cost of defense and the ability of plaintiffs to recover attorney's fees should they receive a favorable jury verdict, these are amounts that we then have to factor into our decision-making. I took that out of the amount because I do want to talk about what the individuals are receiving.
Oh, okay. So
Yeah.
that was my question is, did your calculation of the 413 per year end up being net of legal fees?
If you want the total, which I think you do, $444,000 a year of incarceration if you include everything.
Okay.
If you pull out the attorney's fees, which are delineated to go to the firm, then each plaintiff receives $14.9 million. That's how you get $413,000.
Gotcha.
And when you aggregate the 404, what is that, the total amount?
That's still the $48 million. The $48 million is still the
Oh, it's
total
still the
amount.
48. What-
Yeah, I just wanted to break it down for you
Gotcha.
so you can sort of conceptualize. Again, a $30,000 bump doesn't justify years in prison, but it does show you that the settlement is in two pieces there.
And then the other question I had was, how is the city paying a $48 million settlement?
I really appreciate you looking directly at Bob Senemy, and I will allow him to come up to talk. You can shut that.
Sure. Hey, thank you. Good morning. Bob Senemy, Deputy Finance Director. So the way we fund legal risk in the city is we actually make a budgeted contribution every year into something called the Risk Management Fund, where we set aside money for, the eventualities of settlements like this. Given the nature of this one, we knew about this, as Justin said, back in 2020. After we make our normal budgeted contribution, we do sit down with the law department at the end of each fiscal year and just try to figure out, is there anything else that's truly extraordinary that we need to set additional money aside? And so as early as 2020, we were aware that in a case like this where you had multiple individuals and long prison terms, that it might lead to a settlement. So what we did in trying to plan for that is we did set additional money aside when we had revenue surplus at closeout to begin saving for this case. Now, we didn't know what the amount was going to be exactly, but we did set money aside. So we do have the money set aside in our risk management fund to settle this case.
All right, this is the real question. Did we set aside more or less than the actual settlement cost?
Actually, we set aside the exact amount. We set aside one chunk in fiscal '22 at closeout, and then knowing where this was heading and having a better sense of the amount, we set aside the additional amount to get to the total at the end of fiscal '23.
Okay, all right. That's all I have. Thank you.
Thank you. The previous state's attorney started this conviction integrity unit. I believe they exonerated 12 or 13 individuals. We're in the pipeline from a settlement perspective, is this particular case?
That's a great question. So I've been at legal affairs with the law department since 2018, and the cases started coming in shortly after that. We have had, I'm going to talk out loud, so I'll be thinking, one case that was in 2019, the individual was released, and we, through discovery, after they initiated litigation, were able to uncover that they had secured their release through fraud, through forgery. We were able to settle that case for $125,000 for 17 years of incarceration. Then we had a case where we uncovered another fraudulently secured release through a forged document. We were able to get a motion to dismiss granted. In that case, we paid no money. Then we have 3 other cases that are currently on appeal to the Fourth Circuit, so I don't want to talk about the facts of those cases, but it suffices to say we litigated them aggressively, we had our motions granted, and they're in the appellate pipeline right now. This case and one other case have been settled. The other case that was settled was an exoneration based on DNA evidence. It was an individual named Malcolm Bryant. We litigated that case again through this stage, through summary judgment, and while the motions were pending, we again determined that our motion was likely not to be granted. We would likely go to a jury, and we felt with an exoneration based on DNA evidence, it would be very difficult to convince a jury otherwise. So we settled that case for $8 million for 17 years of incarceration. So we have settled cases at or below the $500,000 per year of incarceration, which is 50% of what juries likely would grant. Based on a nationwide study. So this is the second wrongful conviction case we have settled. We have 3 on active appeal and 1 in discovery, meaning it's currently still being litigated.
So from a financial perspective to the city, if the pattern continues, that we have the wherewithal, the need, the concern to continue to study some of these cases, particularly in that area, my assumption is it will put the city at a huge financial risk and somewhat jeopardy. Is that accurate, based off of your experience?
It's hard to speculate. All we can do is get the cases in front of us. I can say that the cases like this from the 80s and 85 and 87, when the law was different, when the disclosure of materials was not required, there may be more cases, but because we have not seen any and because we've made so many reforms, it is tough to say there's going to be more. There's always going to be examination of old cases. That's the job of innocence projects and things of that nature. But we feel very confident, based on our successful defense of those cases that have been brought forward, that only truly meritorious claims will survive summary judgment.
Okay, I appreciate that. I guess we can arguably say that this has impacted not only the lives of the individuals, particularly in this case, but talking about the other cases, these individuals were again, teenagers. To only imagine to kind of have your life ripped up from under you at age 16 for 36 years? 36 years. Does the city the police department? Do they offer any specific wraparound services outside of just this particular settlement?
I'm not aware of anything involving these three individuals. I do know that in previous cases, under the previous administration at the police department, there had been discussions about reaching out to some of the plaintiffs and bringing them either as mentors or helping them connect with community. I don't know what was done with that, but I know there was discussion at that point about reaching out to them and having them connect with city services to sort of be mentors to youths and to talk about their experience.
I think it's. I think that's definitely honorable. I'm saying more so from the. We know that many of our men that go in, particularly as juveniles, is a term institutionalized, and it's kind of hard for them to kind of come back into society. I think one of the cases that you mentioned, Malcolm Bryant, he died shortly after being released because of, I guess, the pressure of being out. You know, for many of these individuals, they're our family members, they're our friends, they're our neighbors. And again, we know that the residual impact that these cases have, not only on that individual, but for their families, their children. Many of them wind up in the system. Many of them wind up in the social programs that we constantly try to push in City Hall. I guess what I'm asking is not setting up maybe a mentor program for them to kind of teach life experiences to young folks. I guess what I'm asking is from a mental health perspective, from a financial acumen perspective, do we provide any of those services as we've literally destroyed these individuals' lives?
Madam City Administrator, do you know the answer to that question?
Yes.
I don't know.
Yes, thank you. And thank you, Mr. Council President, for bringing awareness to these very real issues. So I would like to highlight and offer the work that MONSE does through their Victim Services Unit, as well as through the new Office of Returning Citizen Affairs. I think that this is something that we can dig into to ensure that we have services for individuals who were wrongly incarcerated as a part of the work that we do through the Returning Citizens Affairs work that's starting in Muncie.
Thank you. And I have one last question. I always ask this question.
Yes, sir.
Everyone up here knows the question I'm going to ask, and I know the answer. But for the record, for the individuals that were part of this case, if they are still alive, are they fully able to access their pension?
Of the three detectives who were named, all three are retired. I'm pulling up the portion of the memo because I don't have it off the top of my head, which I knew you would ask the question. I should have. I'm sure the acting solicitor has it right there, just going to jump in when I forget. The one defendant, Detective Joyce, retired in 1984, so he has been separated for many, many years. The other detective, Kincaid, retired as well. I don't have that on.
Don't have that one as well.
Yeah, I don't have it, sir. I can get that to you. I can tell you back then the pension contribution was 20 years and not 25 years.
Yeah.
That changed, so it'll be an easy enough lift for me to find that. Get to you.
But the expectation is if this case or any other case, this case does not affect their pension.
This case would not, just like other cases we see with police misconduct, that is something that does not affect their pension.
So again, I
correct?
just want to elevate that to this board, to the administration. It's a bill that I worked on while I was a delegate in Annapolis, and I ask this, we continue to do, that when we see cases, particularly egregious cases such as this, and it's coming out of us repaving roads, rebuilding rec centers, putting resources of rebuilding communities that have been disproportionately disinvested in for far too long, that the individual responsible should take some ownership in that. and us paying out their pension for the remainder is problematic, and we should look into it. So with that, I do not have any additional questions from the board. Are there any additional questions? Madam CAO?
Yes, thank you, Mr. Council President. So I do want to read a statement into the record from Mayor Scott, who unfortunately was not able to be with us this morning as he had a family doctor's appointment. But because he cannot be here this morning, he requested that I read the statement on his behalf regarding this specific item. This settlement is an extension of our city's efforts to overcome the decades of issues that have faced our neighborhoods, our police department, and our broader justice system. These settlements are necessary. They speak to gross injustices that were perpetuated against the residents of Baltimore City, and these families certainly deserve compensation for what they have endured. Our city is in a position where in 2023, we are literally paying for the misconduct of BPD officers decades in the past. This is just the part of the price our city must pay to right the many wrongs of this terrible history. Looking back at incidents like the one that prompted this settlement underscores not just how far the Baltimore Police Department has come, particularly in the last few years, but it just shows how painful that progress has been. No one in our city ever needs to be party to a settlement like this ever again. I am committed to doing everything in my power to ensure we do just that, and I know that members of this body share that commitment. Thank you.
Thank you, Madam CEO. I do have one additional question. Sure. With the change of administration, has there been any additional exonerations?
There have not.
There have not. Is the Conviction Integrity Unit still standing?
It is still standing, yes.
Thank you. Any additional questions or concerns? At this time, I will take a motion.
So moved.
It's been moved and probably seconded. All those in favor, please say aye.
Aye.
All those opposed, please say nay. The ayes have it. This item is approved. Thank you so much.
Thank you, sir.
Truly appreciate you coming in.
Absolutely.
As we move on, the next item will be a walk-on request. It's SB 2313616, Department of Real Estate. The request is to approve a sublease agreement with the Mayor's Office of Neighborhood Safety and Engagement for 2700 Raynar Avenue. On behalf of the Real Estate Department, we have
Good morning, honorable members of the board. I'm Eric Evans, Director of Department of Real Estate. This item, SB 23136, it's an interagency sublease agreement that would normally fall on the routine agenda. Unfortunately, due to a administrative oversight, we missed the cutoff for the routine agenda, and so now this is on the non-routine walk-on. This is, unfortunately, the Monzi could not wait to move into the, they needed to move into this space immediately, and so we had to get this done immediately. It couldn't wait till the next BOE meeting.
understood. Just for the record, what's the terms of the agreement?
The terms of the agreement's a $212,000 annual lease agreement between the two agencies.
For how many years?
This actually is, I'm not sure, I apologize, I'm not sure of the actual how many years, but it does have a 90-day termination agreement involved with it.
Got you. Are there any additional questions from members of this board? Madam Director, would you like to talk, or you're okay? Come on up.
Sure.
Stephanie Mavronis, Interim Executive Director. Thank you very much to the Department of Real Estate, BSIT, the Comptroller's Office, the CAO's Office. Monsi, for probably a year and a half, has been working to find co-located space for our team. We occupy the space that Mayor's Office of Criminal Justice used to be in. At that time, the team was maybe 18 people, and we're a team of almost 40. And so we have a really complex hybrid work schedule, making sure our team can hotel and share desk. This space will allow us to do our really important work together in person. We're also excited to be based with the Health Department, who's the leaseholder here. I believe the way the agreement is structured, it's technically a one-year lease agreement with 5 opportunities for renewal for a total of 5 years. The first year's month or rent will be prorated, given when we're moving in. So just want to say this is something we've been working on for a long time. Our team's prepared for the move, and we're looking to physically move within the next 1 to 2 weeks. We've been prepping our team for this for the past few months, as I mentioned, and there's actually going to be a ribbon cutting event next Wednesday with Coppin Heights CDC, which plays a big role in the building. We're excited to keep this space in the spirit of community healing and public health. This space has always been a safe haven when it was the old Hebrew orphanage. And so to have the health department in Muncie really embedded in the community in that way, we're really excited for that and all the opportunities it'll afford for us.
Has the comptroller, myself, been invited to the ribbon cutting?
You will be.
Okay. Schedule's kind of tight, so in a week.
I'll make sure you get all the
important for you guys
information
to-
today.
Maybe we need a notification for that. Sorry for botching your title, Madam Executive Director. Thank you for coming for us. And I know we talked about something in a previous thing. We look forward to work with the administration about aggressively seeing if there's a program that we could stand up. I know the previous administration of the state's attorney had a program and some wraparound services, but definitely, I think under City Hall's purview, we should ensure that we're doing our best job to kind of correct the wrongs of the past with those individuals.
Totally agree. Thank you for that.
I appreciate that. So with that, are there any questions for Muncie or real estate on this particular item? Hearing and seeing none, at this time, I entertain a motion.
So moved.
It's been moved and probably second. All those in favor, please say aye.
Aye.
All those opposed, please say nay. The ayes have it. This item is approved. The next walk-on item is SB 2313863, Department of Planning. This request is to approve the Maryland State Arts Council Planning Grant Agreement for an area around Cab Calloway Legends Park. On behalf of Planning, we have Mr. Director.
Thank you, Mr. President. Board, I'm going to introduce Kim Knox, our project manager.
We don't know who you are, sir.
Pardon?
We don't know who you are.
Oh, I'm sorry, Chris Farrar, Director of Planning.
Thank you, sir.
This project's part of our Green Network Plan, which is our ongoing work with Department of Housing Community Development to help neighborhoods where there's population loss and high vacancy rates work out a plan for their neighborhood with the vacant land that ensues from demolition. In this case, the Department of Recreation and Parks has stepped up to create a new park, Cab Calloway Park, but that takes time, and we stay with the communities and work with them on implementing a lot of pieces of that park planning process. So I'll introduce Kim Knox to explain the project.
Oh, just real quick, Director. Kim, you could come up because maybe you're going to answer this, but I didn't want you to go back before. Does this put like a rider on the land where it won't be developed, it can't be developed in the future? Or how does that occur, like when we decide to make this a park?
Well, it's publicly owned, for one thing, and secondly, we do have a zoning category for open space, which most park property are, so I would imagine that in the future, that designation would be applied to this property.
So this would be a zoning change?
Yes.
Is that planned for this? Is that legislation that's
We
already
haven't
planned for this?
gotten there yet.
The 81 lots are the 81 lots for Cab Calloway are currently owned by the city, and all the liens are cleared. The lots will be consolidated and transferred to the Baltimore Recreations Parks once Department of Transportation puts in the ADA ramps and the sidewalks on Gold, Baker, and Druid Hill, as well as the tree pits that the residents have been requesting.
Understood. I guess what I'm requesting of administration is when we go down this path, I think that we're investing money, a lot of time, the community's involved, that we should change the zoning to ensure that it stays a park. Say an administration or two comes in and, they don't like it as a park. They're not upkeeping it the same way, and they want some fancy developer to come in and do a development there. If we're serious about going down this path, particularly in neighborhoods like this, of creating these really nice, and I wouldn't want to call it a pocket park, because it's much more than that as far as the square footage. That we kind of ensure. So anything that my office can do from a zoning perspective, please ensure that we're kind of working it. And if there's any other type of opportunities out there like that we're going down that path, definitely interested in sitting down and talking to you.
Great. Thank you.
Are there any questions or concerns from members of the board?
Is that, what council district is that? Is that 7?
Yeah, 7.
Okay.
It's right below North Avenue. Any other questions or concerns?
Who's the grantee?
The grantee, is the Baltimore Department of Planning. It's from the Maryland State Arts Council.
Okay, and is there a sub-grantee?
Yes, will be agreement with the Pennsylvania Avenue Arts and Entertainment District to talk with the residents to create a plan on visual art, vertical murals, artistic crossings, signage, and banners that are in the community's vision for their community.
Exciting work. Mr. Comptroller?
I think the city administrator was hoping you were actually going to say the name of Lady Breon or the Black Arts District.
We got close.
And just for the record, the amount?
It's $10,000.
Any other questions? This time we'll entertain a motion.
So moved.
It's been moved and probably second. All those in favor, please say aye.
Aye.
All those opposed, please say nay. The ayes have it. This item is now approved as there's no new business before the desk. Is that accurate, Madam Clerk? All right. We will now adjourn this meeting. The next regularly scheduled meeting of the Board of Estimates will occur on Wednesday, November the 1st at 9 a.m. I'd like to thank everyone for tuning in. Baltimore, we absolutely love you.
Good afternoon. The Board of Estimates is now in session for the receiving and opening of bids. I have the following addendum to read this morning. Department of Public Works, water contract 13996, Montebello Plant 2, sedimentation basins 5, 6, 7, structural repairs. The bid opening has been changed to 11/1/2023. Bureau of Procurement, RFQ 000395, FlowFlex COVID-19 antigen home test kits. That bid opening date is now November the 1st, 2023. And Bureau of Procurement, RFQ 00248, safe syringe disposal kiosk is now being opened on 11/1/2023. Those are all the addendums for today. The first bid that we have this afternoon is Bureau of Procurement, RFQ 00411, fabrication and welding services.
Okay. The first item is Greb Service Incorporated. And that total is 216,000.
Thank you. Sorry. Got it?
This one has it.
Oh, you
The total for Greb Service Inc. is 216,000.
Okay, the next item is Middleton and Meads Company Incorporated. And that total is 238,500.00.
Thanks. For Middleton and Meads Co. Inc., the total is 238,500.00.
Thank you.
The final item on this is Welding Repair, LLC. And that total is 273,000.
Welding Repair LLC, 273,000, and I believe that's all the bids we've received for RFQ 000411, fabrication and welding services.
Next bid is Bureau of Procurement, RFQ 000410, body repairs, OEM, and aftermarket parts.
The first item is Al Packer, White Marsh Ford. And that total is 275,000.
All right.
Hold on one second, 275, wait. No, this is an item bid, prices will not be read. This is an item bid, prices will not be read, we're just going to be reading the names.
Okay. For Al Packer, White Marsh Ford, it's an itemized bid, prices won't be read, and that was the only bid received for RFQ 000410, body repairs, OEM, and aftermarket parts.
Is this the same bid? Okay.
Is that for?
Is it, okay. Okay, so okay. Just read the names.
So I will be reading the following names. We have Auto Body Experts,
Okay. Next one.
Oh,
It's the same bid.
strike my previous comments. We have multiple bidders for this. Apologies for the confusion. I blame it on my small screen. So Auto Body Parts Experts is the next one, as Abigail already stated. We're still on RFQ 000410.
The next item is Base Auto Body and Collision Center, PLE Service Incorporated.
Thank you. Base Auto Body. I'll repeat them all at the end.
Next item is Beltway International, LLC. We then have Beltway Kenwood, LLC. C&W Body and Fender Shop, Incorporated. Herman Bourne and Sons, Incorporated. Lord's Collision Experts. Middleton and Meads Company, Incorporated. Patriot Fire, LLC. And our final item is Wadle Customs, LLC.
All right, I'll read back the names, and this is for our RFQ 000410, body repairs, OEM, and aftermarket parts. Al Packer, White Marsh Ford, Auto Body Experts, Base Auto Body and Collision Center, PLE Service Incorporated, Beltway International LLC, Beltway Kenwood LLC, C&W Body and Fender Shop Inc., Herman Bourne and Sons Inc., Lord's Collision Experts, Middleton and Meads Co. Inc., Patriot Fire LLC, Waddell Customs LLC, and as a reminder, all these are itemized bids, so prices will not be read. And that concludes it for RFQ 000410.
The next item is Bureau Procurement, RFQ 000366, incontinence, supplies, and durable goods.
Okay, we have one bid here. It's First Needs Medical. And that total is 538,698.88.
Can you read that again?
Sure. 538,698.88.
Right, for First Needs Medical, we have the bid amount of 538,698.88.
Yes.
And that's the sole bid received for RFQ 000366, incontinence supplies and durable goods.
The next item is the Department of Finance, bulk tax sale 2023. No bids were received.
All right. That concludes our business here today. Have a lovely fall day, everyone.